Sakshi Manasakshi. I am Priya Goteti. Welcome to Sakshi TV special immigration show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for use of this information. If you need any specific legal advice, please contact the attorney directly. So without any further delay, let's start our show. Hello Prashanthi, how are you and welcome to our show.
Hi Priya, I'm good, thank you. Thanks for having me.
Yeah, it's always a pleasure to have you on our show, Prashanthi. So, can you please provide information on your law offices, practice areas, and your experience?
Yeah, sure. My website is reddyesq.com. We are located in Midtown Manhattan, close to Penn Station. I have over 20 years of experience doing business and family immigration. And you can also reach us at 212-354-1010.
Okay. So, do we have any latest updates for this week?
I thought this week we'll just talk about the alternate, now that the CAP registration is over and it's not possible to get new H1s anymore until next year, until next March. I thought we should discuss what are the available options, that can take the place of a H1 in case, there's a job available and the employer wants to hire someone, but, they can't use the H1 because there's no CAP.
Okay, so viewers, today we'll be discussing on H1b visa alternatives. Before we get into this topic, you can call us on the numbers on the screen for questions related to immigration and also ask some tips. So coming to this H1b alternatives, so what are the available visa options, Prashanthi?
So there are a few, most people think that if you want to work in the United States, the only option available is the H1b. That is not completely true. It's close to being true, but not completely. There are other options as well to work on a H1. And something to remember is that there are also options for people to work, so H1 is for specialty occupations, for professional positions, right? But there are options for skilled workers to come also, agricultural workers to come also through the H2B program or the agricultural worker program. That's a different, maybe that's a topic for another day. But what we're talking about right now is a way for specialty occupation workers, that is high skilled workers, to come to the US when the H1B cap is no longer available. As you all know, just to backtrack a little bit, the H1B visas are specific in number. Each year, 85,000 visas are issued, 20,000 for master's degree holders and 65 for bachelor's degree holders. So once that is used up, and usually what happens is in the month of March, a H1B registration process takes place. And the registration process is basically everyone who wants to apply, every employer who wants to apply for an employee or a prospective employee can file under this H1B registration program. And once it's filed, then what happens is they do a lottery process. And in the lottery, they will pick, just randomly, the computer will pick, they'll do the lottery first for the masters. And then those unpicked masters plus the H1 bachelor's category, they'll do another lottery. So there's a master's lottery and a bachelor's lottery. So masters people get two picks, two chances at the lottery. So it's more likely that you will get picked if you're a master's degree holder. And then after that, they are giving us 90 days after the lottery happens, which is around March 30th, 31st. So from April 1st onwards, we have 90 days to file those H1s. So this is a new process, the registration process, and started 2 years ago, successfully being implemented the second year now. So once this happens, the lottery, we've noticed that there are about 1/3 of the cases, or sometimes even less than that. 25% of the cases gets picked because there are 3 times, 4 times that amount of cases being filed every year. So what happens with the remaining people who don't get in? Or what if you want to hire someone down the road, it's October, but you missed the window for the lottery, then what happens? So that's what we're going to talk about today.
Okay.
Um,
Prashanthi, do we have a second chance in the lottery in the summer or automatic wait list?
Yeah, so one of the first option that we have is that second chance. So as I was saying, the way the process works, they do a lottery and then they pick the cases, they send out receipts, a notice that you've been picked in the lottery, and you have to submit that notice along with the H1. So sometimes though, not everyone who's picked in the lottery will apply. Some people, for example, some employees will file with 2 prospective employers or 3 prospective employers just to increase their chances in the lottery. And that's allowed. One employer cannot file for one employer cannot file for the same person twice, but the beneficiary can use different employers to file, to get 2 chances or 3 chances in the lottery. So when that happens, obviously they're going to only pick one employer. So if all 3 get picked, if he files 3 cases through 3 different employers, then he's going to only file that one case. So those 2 other cases, registration cases, got wasted. Also, cases get denied. So they're not counted as picked in the lottery. They're not counted towards that H1 lottery number. So all these things happen, and therefore it's important that in order to use those unused numbers, that they have another registration. So that's what they did last year, and it's the first time they did it because under this new system, at least they're able to tell who's not filing. They may not be able to tell whose case got denied because that might take some time, but they're able to tell which cases were not filed because all cases have to be filed by June 30th. So they usually have another lottery after that, and you might have a chance of getting picked in that lottery also. Right?
Okay.
So that's your second chance of getting picked. And also in light of COVID and everything that's happened last year, especially a lot of cases registration because when they filed the registration in March, COVID hadn't yet taken up full steam, so a lot of people filed, and then the economy went down and a lot of people were not able to file. So there was a second chance. They had another lottery, and then we were able to file. Not that many more were picked, but some more were picked. So you never know, you might get picked in the second lottery.
Okay. So what are the other alternatives that we can have for this H1B cap petitions?
Yeah, so now the quota is reached, and if you don't get picked in the second lottery as well, you have to wait now until October of 2022 to get someone on a H1 again, because though it starts in April, the actual start date of the H1 is only October. So no one will wait for that long, especially if you have a client, So there's no way of fulfilling your client requirements if that's the case. So that's why it's important to look at what options we have. So the first that comes to mind is the cap exempt H1B. So a number of employers may qualify to be cap exempt, and which means that they are not subject to that 85,000 cap, but they can file their H1 anytime. So a cap exempt employer is an institution of higher education and this higher education institution has to be related or affiliated. Let me start again. An institution of higher education, so for example, a college or university, or an organization that is related or affiliated to a higher institution and is a non-profit. For example, a hospital. If a hospital like Cornell Medical Hospital, if that's affiliated to Cornell Medical College, then they're an affiliated, they're non-profit, so they can file for under the cap. Or a non-profit research organization or a government research organization. So these are some cap exempt employers. But the thing to remember is it's not necessary that you should be working directly for a cap exempt organization. You could be working for a consulting company that places you at a non-profit organization, like you work for ABC company and the end client is actually University of Texas or something like that. So then you're still cap exempt. So remember that. It's still possible to be a cap exempt even though you're not directly employed by a cap exempt. So that's something to keep in mind. So that's one way of hiring people even after the cap gets over.
Okay.
Yeah. So another quick thing, I mean, if you need us to evaluate it, we can evaluate it because it's not as simple as it seems whether an organization is cap exempt or not. So that's something that we will be happy to do for you if need be.
Okay. So in short, we can say that all non-profit organizations and research institutes come under cap exempt?
No, not all non-profit. So governmental research organizations and non-profit that are affiliated to education of higher institution.
Okay.
So that it's important to note that.
Mm-hmm. And coming to this O1P1 extraordinary ability visas, can you provide is it an alternative to H1? Can you provide more details on those things?
Yeah, so another alternative is the O visa.
Mm-hmm.
They're generally, O's and P's are generally reserved for individuals who have extraordinary ability in the sciences or in the arts, motion picture, like the movie industry, television industry. It could be education, it could be business, athletics. So by definition, not many individuals may qualify for the O or the P visa, but it's possible that they could file for an O or P in lieu of the H1B, provided they meet that criteria of extraordinary ability. It's the same, almost similar to the EB1 category of extraordinary ability. So, for example, if you have a doctor and the doctor or an executive chef and the H1 season is over, but that doctor is so well known in his community. He's written many papers. He's a superstar. Or it could be that chef is a really well-known chef, has a lot of press, has been on TV shows, is well-known. So you could do a O1 for that person as opposed to doing the H1. So it's possible to do that. Or maybe I don't know what else. It could be a technical position also. It could be a software engineer position, but you have to show that they have maybe they've invented something, right? They're not just software engineers, but they've actually invented a software. So it is a high standard. Not everyone will obviously qualify for this. But it is something to look into, and it's especially helpful, I think, with executive chefs, doctors, and the high-skilled business people, like well-known businessmen. Also, it might be possible to do an O.
We have a caller, Prashanthi, Ashwin from Texas. Hi, Ashwin.
Hi.
Hello.
Hello, can you hear me?
Yes, please go ahead.
Yeah. Hi, Prashanthi.
Hi.
I have a H1 related question. Hi. So my first H1, it got approved with employer A on January 27, 2014. But later on in month of May, I joined a job with employer B, and they applied for H1B transfer in August, and it got approved. So, but later on, due to some health issues, on January 31st, 2015, I lost my job, and the same employer B, revoked my H1. and then I applied for a change of status to H4. So now my question is, I have almost like 5 years of unused H1, and now it's been more than 6 years since my H1B has been revoked. Now I'm currently working, and if I want to, I'm working on H4EAD, and if I want to move to H1 again, will I come under cap gap? And can I reuse those 5 years of unused H1?
Yeah, so if I understand your facts correctly, you were previously on a H1, but now you're on a H4EAD. Is that correct? And you're
Correct.
working.
Yes.
And
Yes.
when was the last time you were on a H1?
In 2015 January. That's the last one.
So
time.
15, that's 6 years, right? 15, 16, 17,
Yeah,
18, 19,
6.
20. And January 2021 would be 6 years, correct?
Correct. Yes.
So then you just missed the bus because even if you filed in December or just before January 21, you would not be cap subject because you were on a H1 within 6 years. Now, the way USCIS is interpreting it, and if you look at the regulation, it says should have been on a H1 within the last 6 years. So if you're not,
Okay.
then they may not agree that you're cap exempt. They may say you're cap subject, and therefore you'll have to file it, next March when March comes. But there's no harm in trying because these interpretations keep changing, and depending on the officer, sometimes some officers are lenient and some are not. But be aware that if you file and it gets denied, then you lose all the money that, your employer will lose the filing fee, attorney fee, everything.
Oh, okay. I understood. Thank you.
You're welcome.
Okay, thank you for calling us. So coming back to our topic, Prashanthi, most of the MNC companies nowadays are looking option for a L1 visa instead of H1. So can we consider it as like a best alternative to H1 visas?
Yes, Priya, definitely. So we went through the O1, P1, we went through, of course, cap exempt organization. So the next best, actually the better than the O1 is the L1 for an intra-company transferee because it's closest, especially the L1B. There are two types of L1s, L1A and L1B. So the L1B especially is the closest possible visa you could have as an alternative to a H1. So let's go into what is an L1 and what are the different types of L1s, L1A and the L1B, etc. So the L1A is the visa status for multinational executive. So which means a person who holds an executive position. When I say executive, it's managerial. It could be mostly managerial, or it could be that they own the company, or it could be based on specialized knowledge. So executive in position. So they have to prove in an L1A situation that in the past 1 year they have worked in an L1 in a executive position or managerial position abroad in a foreign organization, and that foreign company is sending them to the US to work in their subsidiary company or parent company, meaning that there has to be a relationship between the foreign company and the US company. So that's the second criteria. First criteria, executive work should have been done both at the foreign company and is going to be done in the US company. Second, there has to be a relationship between the foreign company and the US company, and there are certain defined relationships. Not all companies qualify. So it has to be a subsidiary, a parent, a branch, or an associate. So if these two criteria are met, then what USCIS will do is, of course, they will look into, you have to submit documentation, you have to submit duties, and then USCIS will look into whether the documentation shows that, number one, whether both companies are viable companies and actually have business. Number two, they usually prefer that in both companies the business is the same. Like if you're a retail company in India, you should be running a retail organization in the US also. Mostly they look for that. It's not written in stone, but it's better if it's that way.
Okay. So Prashanthi, before going further details on to L1 visa and L1A and L1B, we have a caller, Suresh from California. Hi, Suresh.
Hello, Prashanthi ma'am.
Hello.
I have a couple of questions. One is, currently I'm actually working for a like a company, consulting company, on a contracting basis, and I've been offered a full-time job. When I joined this consulting firm, I did not sign any contract or anything that I'll be sticking with them. When I'm being offered the permanent position, the company B is trying to pull me from company A, but company A, that is a consulting company that I'm with, are saying that there is some contract with me and they cannot release me. So is that actually legal? I mean, I don't see any contract with my current consulting firm, but they say that I have a contract and they're not letting me go. So is that legal, or can I actually work permanent, directly going to the company B?
Yeah, so this is out of the scope of immigration law, but I'll still answer it because it's important and it's related in many ways, because this situation is faced by a lot of H1B people. So this is pretty much employment law, right? So and contractual law, because you have to look into what the contract is, what contract you have with the employer, and if there is a clause in the contract that you cannot leave before 2 years or you cannot leave before 1 year, whether that particular provision in the contract, if that's legal or not, if it's against public policy, because no court will, no matter what even if you've signed a contract, even if it says that you have to work for a minimum of 2 years or whatever, or 1 year or whatever it might be, if the court finds that that provision is against public policy, they will not allow it. Meaning, if you go to court, both parties go to court, you will most probably prevail, because even though it's signed by both parties, it cannot be against the law. So the law doesn't allow for an employer to have kind of bonded labor. You're not bonded labor, right? You're working on your own free will, and that's how a free market is. You're allowed. Employer can fire you anytime, and you as an employee can leave anytime. So to answer your question, no, the employer cannot force you to work. Yes, they can make life difficult for you by not giving you pay stubs, etc., so that it'll be difficult for you to file your transfer. But even for that, there are ways around it. You can complain to the Labor Department and say you're not being paid, and there will be no repercussions against you. So to answer that question, no employer can force you to stay with them.
Sure. Thank you. And the second question is, my wife is actually on H4EAD, and can she file a green card with her company?
Yes, absolutely. Yeah, she can, because a H4, just like a H1, is a dual intent. Meaning you can be on H4 and file a green card also. So it's the same as the H1. So she can go through the labor cert, the perm process and the I-140, and then file the 485 when her date becomes current.
Okay, sure. Thank you.
Thank you, Suresh, for calling us. So Prashanthi, coming back to our topic on L1A and L1B visas. What is the difference?
Right. So as I was saying, the L1A intra-company transferee is for those people who are holding an executive position, and they have worked in the foreign company for at least a year in that executive position, and they are being transferred to a subsidiary or a branch to the US to work in an executive position again. So they will look into whether there's a relationship between the two companies. They will look into whether they're both viable concerns, whether the nature of business is the same. They will want to make sure that the US company has the ability to pay this L1 employee, because if then they're running on heavy losses, then they might question whether, how they can sustain this additional employee. Also, they will look into if it's a startup. It's possible that the US is a startup organization, and for example, the Indian company is sending this whatever his name is, Mr. H, to the US to start up that business. So in that case, then there will be no documents from the US company to show that it's a viable concern, because they don't have tax returns, they don't have profits, etc. So in that situation, they will look for documents. They will make sure, first of all, they want to make sure that you have an office location. So they will make sure that you have a commercial lease. They will ask for bank documents to show that you have enough funds. Enough funds have been transferred from your parent organization or foreign organization to help you start up. So startup capital is something they look at, and there's no minimum or maximum amount. Just enough to maybe sustain you for 3 months should be enough, depending on the type of business. Some businesses need more startup capital, some businesses need less. If you have an IT company, for example, you don't need much startup capital, because your employees are your capital. So as you hire more people, you make more money, right? That's the format. So they will make sure that. So one thing they look at if you're a startup is also, they'll ask you then for a business plan, like a 5-year business plan showing how many employees you intend to hire over the next 5 years, what your revenue or financial growth is likely to be in the next 5 years, what are your plans, your marketing plans, did you do a market survey to see if whatever business you're doing, if it's successful, it's likely to be successful or not in the US. Who your competitors are they, so is there a place for you in the market? So these are some of the things that they will look at. Then from the employee's point of view, the beneficiary's point of view, they look at the duties. And they scrutinize these duties very carefully. So they will first see, see if those duties are executive or not. So when you're framing the duties, you have to be very careful, when we're putting those duties down in the letter. So for example, even if everything, there are executive duties, for example, looking at the profit and loss, preparing the budget, making policy decisions for the company, that's executive. Taking care of other employees, that is managerial, right? Taking care of XYZ department, that's managerial. But if you also say in the duties, picking up phones, taking messages, sending out faxes, that is not executive, neither is that managerial. So even if you have a combination of duties like that, and it's possible that you would, because when you're coming to the US and it's a startup, maybe you're the only employee. So you're doing everything. In that situation, that L1A may not get approved. So that's something to keep in mind when framing your duties. So these are the things.
Like L1A is for managerial role or for executive role or for both?
Both. L1A is for both.
And I hear many people, like when they come on L1A, they file green card under, I think, EB1 category, right? So is it?
Yeah. So that's the advantage of an L1A as opposed to an L1B. Is the L1A is an EB, you qualify for EB1, multinational executive. There is a separate employment-based classification for these type of people, and you don't have to be on L1 first to take advantage of it. You can come on a green card directly. So an EB1 has the same criteria as what an L1 has, multinational executive. So it's the same standards pretty much as that of an L1. So yes, once you file for an L1, after 1 year is over, you can then file for an EB1 petition.
Okay.
If you're here in the US. So you can file directly there is no perm, there is no labor cert involved. You can file directly for an I-140 and 485 also, because EB1 is current, right? It's very close, and it's on and off, but right now it's current. So you can file for an EB1, I-140 and 485. Depending on what the visa bulletin says. And you can get a green card in, say, 12 months. And that's what a lot of multinational companies do. But remember, Priya, it doesn't have to be a multinational company to file an L1A. It's just
Okay.
easier for a multinational company to file because they can easily show that they have X number of managerial positions, right? If it's a small company, you only have one manager most probably. But if it's a huge organization with thousands of employees, you'll most probably have many managers. So it's easier to show multiple people are an L1A. And that's why you see that volume wise, MLCs do more L1s than smaller companies do.
Follow-up
And the other,
question on this, Prashanthi, on L1A, we can file under EB1 category. But suppose if a guy is on H1B or somebody is working on EAD or H4 EAD as a managerial position in MNC company, can they also file for EB1 category, or is it only for the L1 visa they can file EB1?
so you don't have to be on an L1 to file EB1. But at the same time, it doesn't mean that anyone who's on H4 who's working in an executive position qualifies for the EB1 because the EB1 qualification is same as the L1, meaning that you should have worked in an executive position from the last 1 year at the parent company, at the foreign company. If you have not, and they're deputing you as a transferee, L1 is an intra-company transferee. So they're deputing you to take care of the US operations. So if you've never worked with the foreign company, then you will not qualify for the EB1 or the L1.
Okay.
So just further on the same topic, so the advantage of an L1A is of course that green card which you can file and you get it immediately. There's another category, another reason why a lot of MLCs file L1, in fact they file more L1s than H1s, is because they can get something called a blanket approval, which leads us into the L1B. So for an L1B, an L1A we have already talked about. L1B is everything else is same as the L1A. The only difference is now it's not an executive or managerial position, but it is a position that requires certain specialized knowledge about the product or processes of the company. So, for example, if you're using certain software which is unique to your company, which you have invented, and you are using that and implementing that at your client side. So the person, it's only an employee who has learned that will be able to come then to the US and implement that at your client side. Otherwise, you'll have to train a new person, and that takes time and money. So that is the L1B position. You have to show that it is some kind of specialized knowledge in a process or a software or something, a product. It doesn't have to be unique knowledge, but it has to be something that is not easily available in the market. So a lot of companies file L1Bs because they have knowledge of the project. They're working on a specific project and they continue to work on that project after coming here because they come here because the client needs them on site. So that is an L1B. And the advantage of an L1B is if you qualify for a blanket, that means if you have filed, there's a certain criteria. I think you need to file more than 10 L1s and you have to have certain number of branches worldwide. Then you qualify for an L1 blanket. So the L1 blanket, you don't have to file anything with USCIS. You just file it at one time and then you can keep bringing people. All they have to do is submit their documentation at the consulate. And the consulate decides whether, to approve or deny. And then they come in directly, just like just like there's some other petitions like the TN, etc., which, follow the same principle. So nothing has to be filed with USCIS. Like the H4. You don't have to file with USCIS. You can come directly on a H4. Unlike the H1, where you have to file the approval first for the H1 at USCIS, it gets approved, then you go to the consulate, then you get a visa. So it's a two-step process for most other visas. So that's the advantage of the L1B. So L1A and L1B, these are the two really good options for people who can't travel on a H1.
So Prashanthi, for L1 visa, I think that there is no specific labor laws included. So most of the employers pay very less or they pay basic amount and provide some allowances to L1 employees who come as a deputy to USA. So is it legal?
Yeah, so it's interesting that there's so much scrutiny on the H1 and so much scrutiny with how many dollars they're paying. Are they paying prevailing wage? Are they paying actual wage? 101 rules. An amendment has been filed or not? Is it a specialty occupation or not? But the funny thing is, and there's criticism, and there seems to be a lot of criticism by pro-jobs, American jobs organizations saying that, these people are taking away our jobs, these MLCs are coming in. But the funny thing is, these MLCs actually are using L1s, they're not using H1s. And it is the L1s who are not, they, as you said, don't have strict rules. There's no prevailing wage. Unlike a H1 where the prevailing wage is in fact in most instances higher than the actual wage that is paid in that place. So they are being paid sometimes more than citizens or green card holders. So for an L1, there is no prevailing wage, meaning they can pay any wage. And the other thing, as you pointed out, is for the L1, they can pay in their home country. They don't even have to pay them here. They can pay them in rupees in their home country and just pay them an allowance here. So actually, and it's so surprising, the politics of it, that no one questions the L1 while they go on, harping on the H1 and how the H1 is taking away jobs, when actually the H1 has so many checks and balances. I'm not saying there's no fraud, there's fraud everywhere. But, as a program, the H1 has many, many more checks and balances to make sure that, jobs are not taken away, or everybody's treated fairly when compared to the L1. But historically, nothing has been done with reference to L1. It still continues as is.
I hope there will be some loss even for L1 employees. Okay.
And also another thing, Priya, is there is no cap. Any number of L1s can come in. Unlike the H1 where there's a cap. So that's another restriction which doesn't exist for the L1.
So like we'll be having like L1A for executive and managerial, L1B, a blanket as well as individual is also allowed, right? Instead of blanket for L1B visas, individual.
L1B individuals also can be filed. It's only after you file a certain number of L1Bs that you even qualify, for the blanket L1B.
Got it. Yeah. So like after this L1, there's one more thing like TN visas for Canadian or Mexican, like for Mexico, and also like can you provide more details on those kind of visas?
Right. So another really good visa, if you have employees who are Canadian or Mexican citizens, is the TN. You can't beat that because it doesn't have the restrictions of a H1, and it's not as hard to get as initially. The L1 is hard to get initially. But once you get it, it's easy to stay in the L1 status. But TN is not hard to get either. So it's a very simple, straightforward thing. So basically, they're designated occupations for Canada and Mexico, right? And those designated occupations are available online under NAFTA regulations. So as long as you fall under one of those occupations, and as long as you have the education that is specified in that document under that occupation, you qualify. For example, if you're an IT person, then I think they have, I don't remember whether it's software engineer or systems analyst, one of those positions, and they say bachelor's in engineering required. So it's not even specific that bachelor's in computer sciences has to be required. It can be bachelor's in engineering, unlike the H1, which is so specific as to, and there's so many issues with reference to specialty occupation. This is just 1, 2, 3. If you qualify, you qualify. There is nothing to explain in it as to how they qualify, and it's not open for interpretation. Because as long as you have a bachelor's degree in XYZ as per that document, and as long as it's that position, you qualify. And the other great thing about the TN is that you don't have to apply for anything at USCIS. So there's a no two-step process of approval. There's only one step. All you have to do is go to the consulate. You can go by road, you can come by road, or you can go to the airport, the CBP at the airport, and you have to submit your documentation. There's a package that is prepared, basically just an evaluation of your degrees, a letter explaining from the employer what you'll be doing and how you qualify, right? And that's about it. There's your TN. So most TNs do get approved. So it is not a bad idea to have people, I mean, if you want to route them to the US and you can't route them directly due to whatever reason, having offices in Canada or Mexico, getting them to work there for some time, and they get permanent resident status in those countries. It doesn't take 15 years, 100 years like it does here, 150 years. If you're an Indian national, if you're here, it doesn't take that long. It takes a few years. Get them to get their Canadian citizenship or whatever, Mexico citizenship, and then apply for a TN and bring them here on TN. So it's not a bad workaround for people who can do that. And you're easy enough proximity wise. Canada and Mexico are close by, so you can easily open your offices there and supervise, etc. Most companies have, IT companies, I know a lot of companies that have offices there. So it's something that is doable. And there's a lot of great talent in Canada and Mexico also. A lot of Indian nationals, at least to Canada, there are a lot of people settled there. So you have talent there, which is often people forget about it. It's often forgotten. So it's something to keep in mind.
Okay. So, viewers, if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@readyesq.com or call 212-354-1010 or visit www.readyesq.com. So, we discussed about this Canadian visas and Mexico's. So, what about the Singapore or child Australian E3 visas?
Right. So, so the other alternative to the H1 is the H1B1. So the H1B1 is for Singapore and Chile. And these countries have a separate quota. I can't remember how much it is, 10,000? I don't remember, 5,000 or 10,000. So the criteria is exactly the same as the H1. But so it's a great alternative and they rarely get filled. So if you do have people, again, you have great talent in Singapore. I don't know about Chile that much, but Singapore, definitely there's a lot of good talent. So for those, and mostly people are looking for IT professionals because that's 80% of the market is that. So that's another way to nurture people there and then bring them in on H1B1. Have an office in Singapore. Singapore has a great market and great facilities, etc. So that's another way of doing it. Another way is Australia is the E3. A lot of our Indians settle in Australia. That's the next best. I think after the US and Canada, it's Australia. And it's not that difficult to get Australian citizenship once you're there and once you're there for a certain period of time. So again, that's another source of new workers. The whole problem now is that there's so many requirements, especially in the IT space, that are not being fulfilled. And all the requirements are going abroad because there's not enough people here to do those jobs. A lot of people don't know that. So, and everybody's trying to source people on H1, and that won't always work out because there is a cap on H1s. So you have to figure out these other ways of sourcing, your employees from other countries. So Australia is another great place to source employees. You can get the E3. The E3 is again very simple. It's like the TN. You only have to file an LCA and then file a petitioner letter, and the criteria is similar to a H1 where you have to show that it's a specialty occupation. And you don't have to file anything with USCIS. So there's no two places where scrutiny happens. There's only one place, the consulate, and usually the consulate, I haven't known them to be very strict about giving E3 visas. It's easier. So all they have to do is go to the consulate and apply for an E3 directly, and they'll get the E3. So that is really another great option. And you have to remember, for all these L1, TN, you can get your dependents also here. And for the L1, in fact, the dependents can work, just as certain H4s can work. Not all H4s, but all L1s can work. L2s, L1 dependents can work in the US. So that's, something to keep in mind, the E3 and the H1B1.
Okay, Prashanthi will come back to this topic. We have one caller. Hello.
Hello.
Yes,
Hello,
please go ahead with your.
This is Ravi from Cleveland area. My question
Hi.
is, I've been on L1B for the last 3 years, and last year I moved to H1. So my question is is H1 valid for 6 years, or is only whatever the remaining 3 years?
Good question, and the answer is that it's they count the period of L1 against the H1 period. So if you've been on L1 for 3 years, then you only have 3 years left on the H1. So you need to file that green card as soon as possible and get the I-140 approved.
Okay. Thank you.
You're welcome.
Prashanthi, just a follow-up question on this. If a person worked on L1 visa in a company, then he moved on to H1 visa in a B company, but still he can apply on EB1 category because he came on L1 but on a different company.
Yeah, so he can only, a good question again. He can apply for EB1 only if he is the last 1 year out of the 3 years he has worked as an executive in the foreign company, number one. 3 years out of the last 3 years, at least 1 year he should have worked in the foreign company as an executive, whatever his status be right now. And second, he is presently also working as an executive in an executive position. So if these two criteria are met, there's no reason why you won't qualify for an EB1.
Okay. So coming back to our other country visas, so is there anything you wanted to add on that, like T and E3 visas, Prashanthi?
Yeah, so then the next one I wanted to talk about was the E1 and E2 treaty trader or treaty investor visas. Now, this is another category. Not all countries, there's a list of countries that qualify. India doesn't for the E1 and E2. But again, we're talking about sourcing tech people from different countries. You don't have to bring them only from India. It could be Indian nationals who have settled in these other countries, right? Or it could be, nationals from that country. So I've noticed our focus of our consulting companies is very narrow. They don't, they need to broaden their horizons and find new talent in other places. So the other one is the E1, E2 treaty trader or treaty investor visa. So the E1 and E2 allow nationals of countries in which the US basically has trade treaties to invest in the US. And they can receive either an E1, and then they're called a treaty trader, or an E2, then they're called a treaty investor visa. So an E1 treaty trader is suitable if the foreign national has, a multinational employer, same as an L1, who's willing to transfer them to the US, and the company has significant trade between the foreign country and the US. Okay, so in this situation, this is different from the L1, actually easier, because you don't have to establish a company in the US, and you don't have to show the viability of that company, and you don't have to show the relationship between that company and the parent company. So the person is coming from a multinational company, and the only criteria is there has to be significant trade between that company and the US, which means they have to have a significant market in the US. And then he can come and to do, trade between that foreign country and the US. So the only criteria is the employee must have skills, obviously, which are essential to the operation of that company trade. And dependents of the E1 visa are allowed to work. So again, this is similar to an executive situation, but it's easier in the sense that all you have to show is that, that company that he worked for has a business in the US and is doing regular trading in the US. For example, I can say say the company is into trading of garments and all their garments are manufactured in India and sold in the US. Then you can send your your manager, whoever person who has a background in this kind of trading, maybe a buyer. You can send a buyer to source and to take care of your marketing here and to sell. So, that's really much better than the other one. Now, the
Okay.
other category under the E.
Prashanthi, before going into other category, we have a caller who now from Texas. Hello.
Okay.
Hello.
Yeah, hi, Prashanthi garu. This is Nenavat speaking. So I have a
Hello.
question. So I have my prime H1b and as well as the second H1b is the concurrent H1b. So does it, if I travel to India, so do you think it's going to be any problematic because of the have two H1bs?
So you have a concurrent H1, correct?
Yeah, I have prime H1b as well as the concurrent one. The two H1bs.
There's no issue on your status. There is no issue for status. You can be on both H1s at the same time. As long as you file it as a concurrent, you're allowed to be on both. And so therefore, there will be no issue on travel. So if you have a visa for either one of them, you can travel on that. Or even on, you don't even need a visa with your present employer. Even a past visa from a past employer will do.
Okay. Does it any effect on like the time of the visa interview or something like that?
I'm sorry?
At the embassy, at the time of interview, does really make any effect or like some?
No. You should, whatever questions they ask you, you answer truthfully. You're allowed to do 2 jobs as long as it makes sense to do it. You can't work 120 hours a week, but you can work 80 hours a week. You can work 60 hours a week, right? As long as it makes sense.
Or do we need to present both the H1B copies at the time of interview, or do you need to show only prime H1?
Just show the primary H1. You just need to show one H1 to get the visa. And better than showing the part-time one, show the full-time.
Okay. No need of showing the second one, right?
No.
Okay. Gotcha.
If there's ever a question asked anywhere, you should disclose it.
Oh, okay. Until here and that, we should not, right?
Yeah, there's no need to, because that is not that's not essential to getting your visa.
Oh, okay. So there is no problem at all.
No.
Oh, okay. Thank you.
Okay, thank you for calling us. So Prashanthi, coming back to our topic, so we were discussing on the other category.
Right. So I think we discussed about the E1 treaty trader. The other one is the E2 treaty investor, which allows foreign nationals to invest, preferably a substantial amount in the US, and to obtain E2 visa so that they can directly manage their investment. So in this case, for example, a businessman comes from India and wants to buy a restaurant, say, or a chain of hotels. So this is the perfect, well, can't come from India because India is not part of the agreement, but coming from another country which is part of this. So again, being a citizen of a different country helps with US immigration especially. But yeah, you could be an Indian national, but you could be a citizen of some other country. So if that is the case, then you can invest in buying that particular restaurant, and you can run it on an E2, and you have work authorization, and your dependents also have work authorization. So that's called the E2, and you can also file for a green card on E1 or E2, but you have to go through the labor cert process. So it's a little tricky to do the green card. It's not as easy as the H1 because there's also some intent issues. But overall, if this is your purpose, this is a great visa to have. This is for basically entrepreneurs who want to come and start a business here. So as opposed to the EB5, it's like $1 million, 900 and something in an underserved area. This has no minimum or maximum amount required. It's just the amount that is required to fund your business. So it varies, depends on the industry, right? So a more capital intensive industry would need more investment. But if it's a smaller business, then you'll need less. So really, there is no minimum or maximum unlike an EB5, but it serves the exact same purpose as an EB5. So, and also your dependents can come in and are eligible for work authorization. So that's another great visa to have.
But Indian citizens cannot apply for this. I just wanted to
No,
check.
unless they are Indian nationals and citizens of some other country as well, who are part of this in the list, then they can. There are a lot of countries, but India is not one of them, unfortunately.
Okay. So all these alternatives that we are looking is like for the employment. We also have a different kind of alternatives like OPT or CPT for students. So can somebody on H1 move to a CPT or like OPT as a student and meet like an alternative?
Yeah, so if you missed your bus for the cap because either you couldn't file or employer didn't want to file, or you filed but you didn't get picked in the cap, then on an F1 it's possible to while you're on an F1 get CPT, curricular practical training. So you can be going to school full time and also have a full time job, and there are a lot of universities that offer that. So usually they'll have they'll have lessons, they'll have classes on Friday, Saturday, Sunday, and then you work the rest of the week. And you only have to be on campus for Friday, Saturday, and Sunday, and the rest of the week you can be working wherever your job is. So that is CPT. You don't have a life, of course, because you're either studying or working all the time. But yeah, it's tough to be a non-immigrant. But yes, a lot of students do that. So that's the CPT program, and that works better than a H1 in the sense that there is no prevailing wage. You don't have to file an amendment every time you change. You don't have to pay a minimum wage, less regulations. As long as you meet, you keep your CVIS active, you inform your DSO, college DSO about, if you're changing employers. As long as you do that minimum, whatever is needed, it's a very easy status to be in. Sometimes it just, you fall out of status because the DSO makes a mistake. Because of that electronic CVIS system, it's unforgiving. So any small mistake you make, sometimes you fall out of status for no fault of your own, and then you have to apply for reinstatement, and it's a big mess. Okay. So other than that situation, I think it's pretty easy to maintain CPT.
Okay, thank you so much, Prashanthi. And viewers, if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@readysq.com or call 212-354-1010 or visit www.readysq.com. So we'll be back next week with more interesting topics on immigration. This is Priya Goteti signing off. You are watching Sakshi Manasakshi. Thank you.
Thank you.